Chase.
Yeah, yeah.
Okay.
May I know your name, please? For participant 1004 team, can you please tell me your name?
My name is Muhammad Aksan Adiat Maamir.
Oh, sorry, I think you have entered the wrong room. You should enter room 2.
Oh, forgive me. Is the opening ceremony has already ended? Uh, dear committees, should I still move to the other rooms or should I just stay?
Um, you should move to the other room. You should go to room 2. Yeah.
Okay.
Do
Thank
you
you so
have
much.
the link?
I'm so sorry.
Do you have the link for room 2?
Yes, I do have the ring.
Okay, okay.
Thank you so much.
Welcome. I don't know. Do we have opening ceremony? I didn't know that we have opening ceremony. Oh my gosh.
I think we had one person is waiting in the lobby, but there are also 1004. So I am trying to ask Uma, has there been any change? Has there been any change to the Google Docs? I think you just start texting the judges and all that because it's 9:39 right now. The judges and the
The
party.
judges will enter the room, right?
Yeah,
We don't have to text them, right?
we do if they're like late
Oh,
because we need to follow time. Do you have the judges' numbers?
yeah.
Okay, then send them the template at the bottom and the link. Hmm. I have. Luckily, I have the team member's number. I will handle the team. You handle the judges. One oh oh one and 1003. There's ours 1003. Okay. And
Do we have participants? Not
yeah,
yet.
not yet. Second. 1003. Afif, Ahmed, Hanif, and Johanna. Their numbers are not here. But I do have Sahir Ramon's number. Johanna, okay.
Oh, kenapa 2, Pak?
Berarti baru pendapat masuk. Keluarin. Cobain, kasih besarin. Ini orang yang tadi. Berdua ya kok, coba pokoknya. Ya, 15. Di rumah nih, yang paling baru, yang preliminary.
Oh, karena jalan.
Okay, we request for the participants to please open their cameras. Turn on the cameras, please.
For the participants have just entered the room, can you please turn on your camera?
Keluar dulu baruan apa? Uban aku keluar.
For participant 1005R, may I know your name?
My name is Aremal,
My name is Raihan Christopher Lubis.
and we are from the team 1005.
Sir, can you please repeat your name?
Saher Remal Agung Taktaran for me, and
My full name is Raihan Case Tufail Lubis.
Okay, got it. Thank you. And do you have the background picture?
oh, okay.
Yeah, you can set it now.
You mean like turning the laptop 360 degree?
No. Just the background picture.
Oh,
Just
okay.
like, yeah.
Okay.
Is it okay?
I'm sorry, but we can't. We don't really know how to change the backgrounds here in Microsoft Teams.
Do you see the 3 dots above the Microsoft team? It's beside
The
people, raise, react, view, Q&A.
okay.
You have more. Yeah. Click on the more. And do you see the video effects? Video effects.
I'm sorry, but there aren't any options for any video effects. There are only device settings, gallery, and live captions, keypad, etc.
I'm afraid it's different than mine. Muga, do you have any idea?
Do you see background effects?
No.
No, we don't see nothing.
Okay, wait a second.
Cuma yang mau sekarang ketemu kayak gitu juga.
Okay, hold on. Let's... So I think maybe your Microsoft Teams do not allow background effects. Yeah, so I think it's gonna be okay if you didn't use it. If you can't access it, it's no problem.
I think it's okay lah. Because the background picture is only for the judges to identify whether you are respondent or yeah. But it's okay because you have put your name, your username as 1005 respondent. So I think it's okay. Yeah.
Okay.
Okay, thank you very much.
You're welcome.
The participant that just entered, can you please turn on your camera?
Greetings, my name is Reza Ferdiansyah and we're from Teams 1005 as a spectator.
Greetings, my name is Renal Sebastian Siholan. I am from team 1005 as a spectator. Thank you.
For you guys have just entered the room, can you please, do you have the background picture? Kindly set it as your background.
Pardon us, but for sure, we still do not know how to apply the background because on our laptop is not compatible.
Okay. It's okay, it's okay.
Participant 1003A, can you please change your background?
I'm so sorry, our device is not compatible to change the background also.
Okay. This is gonna be a problem.
For participant 1003A, may I know your name, please?
My name is Afiq Ahmad Hanif.
Okay, thank you. And for 1005R, may I know your name? Can you hear me? Participant 1005R.
Okay, my name is Remal Agung Daktaran.
And my name is Raihan Case Tufel Lubis.
And for participant 1003A, that just entered just now, may I know your name? Johanna, is it?
Greetings. My name is Johanna. I from team 1003A.
Okay, thank you.
Okay, all participants make sure your camera is turned on and your mics are working properly. Okay?
So since all participants are here now, I'm going to brief you guys a while regarding the competition. So good morning to you all. Welcome to the briefing session. Today we'll discuss important rules regarding time allocation and general guidelines to ensure a fair and smooth competition. So let's begin. So during the rounds, teams will have a total of 35 minutes to present their case, including rebuttal and sur-rebuttal time. Please keep in mind the following time allocation rules. First, teams have the discretion to allocate time for each speaker. You can decide how to distribute the time within the team, considering the content and structure of your presentation. Rebuttals can be assigned a maximum time of 5 minutes. This allows teams to address and counter arguments made by the opposing side effectively. If you require additional time, speakers may request an extension from the judges. However, it's important to note that the judges have full discretion in deciding whether to improve such requests. Any extension granted will not exceed 5 minutes. So during all oral rounds, teams must maintain and refrain from disclosing any identifying information, including their institutions. Please only refer to yourself using your team codes. Scouting, which refers to observing the oral submission of another team, is strictly prohibited unless your team has officially knocked out of the competition. Please avoid any form of scouting to ensure fairness and equal opportunities for all participants. To help us identify and allocate the appropriate roles during the competition, please enter the meeting room using the correct team code format. Follow these guidelines. Participants must enter the meeting room using their team code followed by A for the applicant and R for the respondent. So thank you for your attention and cooperation regarding the time allocation rules and general guidelines. We believe that these rules will contribute to a fair moot competition. If you have any further questions and clarifications, please don't hesitate to reach out to the organizers. So good luck to all participants. So may I know who's going to be the first applicant? Can you guys hear me? Who's going to be the first applicant?
I believe that team 1003 applicants.
Sorry, can you repeat again? Who's going to be the first applicant?
We believe that the first applicant will be our team from 1003A.
Okay, for the respondent, who's going to be the first respondent?
For the first speakers, I think it will be me. Saya Ramal Taktaran.
Okay. And for the respondent, may I know the time allocation for the first respondent and the second respondent? Each of you, the time allocation.
For me, as the first speaker, I will speak for 15 minutes with 5 minutes rebuttal. And
for the second argument, I will be speaking 10 minutes, 15 minutes, pardon.
With each 5 minutes of rebuttal.
So for the first respondent, it's 15 minutes, and for the second respondent, it's also 15 minutes.
Yes.
Okay, thank you. And how about applicant? The time allocation for each of you.
For the first speaker would be 16 minutes, and for the second applicant would be 17 minutes with 2 minutes of rebuttal session.
Okay, thank you. Sorry to interrupt. Can I just make sure that team 1005 is here?
Yes, we are here. Yes.
All right, thank you. So are we waiting for the judges to come into the room? All right, so I will inform the judges to enter the room. Sorry to interrupt, judges. Currently, we are waiting for another judge to join the meeting room. We will wait for another 5 minutes, and after that, we will start the round. Thank you. Sorry for interrupting. May I know the round has started? Chase, may I know if the round has started? Oh no, we are still waiting for Mr. Muzamil. He's not in. Alright, so please do start the round now. Okay. So good morning, Your Excellencies. Welcome. We appreciate your presence here today. Before we begin, we would like to ask Your Excellencies to determine who will serve as president for this round. You can take a moment to decide among yourselves. Your Excellencies, could you hear me?
Yes, I can hear you. I do not have any problem being president, but if someone wants to be a president, I have no problem.
Yeah, Ibrar, you can be.
All right, thank you. Okay, so can we start? Please
Thank
proceed.
you, Your Excellencies. So, may I know who will be the president for this round? Because just now I couldn't hear clearly.
Okay, so I'm the president for this round.
Okay, so thank you. So Mr. Ibra will preside over this round as the president. So with the president elected, let the round commence. I now invite the participants to present their arguments. So dear participants, you may start when you are ready.
Good morning, Mr. President, Your Excellencies, may it please the court. My name is Afik Ahmad Hanif, and I have the honor to appear on behalf of the Republic of Azura, the applicant in today's proceeding. I will speak for 16 minutes, and my co-agent, Ms. Johanna, will speak for 17 minutes. And with your permission, we reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 16 minutes, we will be submitting that Republic of Azura acted in accordance with international law by launching military attacks against United Provinces of Roxana. And my co-agent will be submitting regarding our second submission that Republic of Azura violated international law by launching military attacks against United Provinces of Roxana and must pay reparation for the damage suffered. If this court doesn't have a preliminary inquiry, may I proceed to my first submission?
Counsel, can you please repeat your name?
My name, Your Excellency, my name is Afik Ahmad Hanif.
All right, please proceed.
On 15 October 2022, Republic of Azura launched a military attack against provinces of Roxana due to the threat by developing hypersonic nuclear missile increasingly threatening. Here, we submit that the use of force committed by Azura is justified under international law. Your Excellencies, entering our first submission, we submit that, firstly, Republic of Azura's military attack constitutes as self-defense. And secondly, Republic of Azura doesn't need to pay for reparations. In this first major arguments, we submit that, first, Azura's military attack act in accordance with the requirement of necessity. And second, the attack complies with the IHL rule. Entering our first argument that Republic of Azura constitute a self-defense. First, in the Caroline case, there are several prerequisites to determine military attacks as self-defense, which are A, necessity, and B, the attack complies with IHL rules, such as proportionate, and the attack led to a legitimate military object. In the Caroline case, to fulfill the necessity element, the attack must be instant, overwhelming, leaving no choice of means and no moment for deliberation. In the present case, possessing nuclear weapons could constitute an inference of willingness to use them, and the hypersonic nuclear missile under the possession of United Provinces of Roxana clearly possess a threat to Azura's national security. Therefore, the attack is to eliminate an imminent threat. To our first sub-argument, we submit that Roxana failed to settle their obligation to negotiate in good faith for nuclear disarmament. Non-proliferation of nuclear weapons gained the status of use coherence norms, and the Non-Proliferation Treaty is the most ratified nuclear treaty that states have practiced. In this case, as a form of implementation of Article 6 Non-Proliferation Treaty, which stated that states should pursue negotiations in good faith regarding nuclear disarmament. In the present case, Republic of Azura approached United Provinces of Roxana to engage in a dialogue as a form of good faith to reach an agreement on disarmament that could not resolve the threat that the nuclear weapon possessed. Therefore, United Provinces of... Yes, Your Excellency.
Council, what are the requirements of self-defense? As you have cited some cases, but you have missed on the provision that deals with it, the very law and provision.
I'm sorry, Your Excellency, can you please repeat your question?
Yes, I'm asking what are the requirements and test of for invoking self-defense provision, and which specific provision of law deals with it? Like you have cited cases, but you have missed on the law.
Yes, Your Excellency. So the requirements for invoking a self-defense, there must be an armed attack occurs first. But that is why we brought up the current case, which in our case, there is similarity where there is an absence of attack in that case to invoke a self-defense, Your Excellency.
Okay, so there is absence of armed attack, and then you are invoking self-defense article, right?
Yes, Your Excellency.
But you are not fulfilling the very essential requirement of self-defense.
But in the stats practice, in the Caroline case, there is a similarity between our case for there is an absence of armed attack. That is why we brought up that case for our argument, Your Excellency.
And what is the rule laid down in that case?
Excuse me, can you repeat your question? I cannot hear
What
you
is the
clearly.
rule? What is the rule that has been laid down in the case that you are citing?
So in the Caroline case, there is an absence of attack, but there is the Caroline formula that stated for the necessity element to invoke the self-defense, Your Excellency.
Council, you cannot pick and choose just one element and just frame your own whole argument around that. You have to contextualize the rule, in what context that rule was laid down by the Honorable Court. So are you not aware of the context in which this rule was laid?
We do aware, Your Excellency.
Okay, please proceed. And what about the article of the law that deals with self-defense?
I'm sorry, Your Excellency, can you repeat your question?
What provision of law you have invoked? Like what provision of law Azura has invoked for the sake of self-defense?
It is stated that in the charter, Your Excellencies, in Article 51 for self-defense.
Okay. Please proceed.
To our second argument, we submit that the attack complies with the IHL rule. To establish that an attack has complied with the IHL rule, it must determine that the attack is directly led to the military object, and second, the military attack is proportionate. On our first sub-argument, the attack is directly led to a legitimate military object. A military object refers to objects which, due to their nature, location, purpose, or use, make an effective contribution to military action and offer a definite military advantage. In NATO bombing case campaign, the court refers to determining a legitimate military object when the object gives effective control over the military activity. Azura's attack were only directed towards United Provinces of Roxana's military facilities. The Azura's attack did not violate the IHL rule and were only directed towards a legitimate military object.
Council
argument. Yes, Your Excellency.
It's not the proportionality principle is premised on the balance when there is an armed attack by the opponent state, and then you will have to attack them back on the same of the same gravity. But here we are seeing that there is no such attack, as we have already discussed. So how can you strike a balance of this proportionality?
Yes, Your Excellency, as I'm about to explain to you on our second sub-argument, the military attack is proportionate. In accordance with the principle of proportionality in attack, it is prohibited to carry out an excessive attack that would cause injury to citizens in relation to gain a military advantage. Azura's attack was directed towards legitimate military objects and did not cause an injury to civilians. Thus, the attack is proportionate. Move to our second major argument. Yes, Your Excellency.
Council, this honorable bench is very well aware of the rule and principle of proportionality. What we are requiring is that how do you substantiate and satiate the requirement of proportionality in the current facts, in current context? Because you have to satisfy that the balance we have struck is, that is the same balance which is envisaged by the proportionality principle as well. So how do you justify the proportionality element in light of the current facts? Because we are seeing that, Azura was the first state who, launched the attack on Roxana state. So how can this argument can be brought that there was a proportionality, or, the attack was of the same gravity as, the attack probably launched by the opponent state?
Yes, Your Excellency, as we previously mentioned before, that this attack was our last resort since there is an imminent threat by the danger of possessing hypersonic nuclear missile under the possession of United Provinces of Roxana. Therefore, we explain that our attack is proportionate.
So just imminent threat is, enough for, striking or invoking the proportionality principle, that in case there is an just imminent threat, but they have not done any act which can, justify your attack. And you are saying that way, the way you are saying is that way any state can come up and say that, we have this imminent threat from that specific state, and that's why we are, launching preemptive self-defense, and our act or specific act is very much in accordance with the proportionality principle of IHL. So just the imminent threat is sufficient to invoke such attack.
Your Excellencies, if I may refer you to the compromise that it is stated in the Annex D, the statement from Republic of Azura's Ministry of Foreign Affairs stated that the Republic of Azura has exercised its right to self-defense under international law as a last resort after exhausting all diplomatic efforts, Your Excellency. Therefore, we did try to engage in a diplomatic approach to United Provinces of Roxana, whereas it cannot resolve the threat of the hypersonic nuclear weapons. Therefore, this attack is our last resort for our self-defense.
What is the requirement of the imminent threat? Like, before seeing that there is an imminent threat from any specific state, what needs to be fulfilled?
I'm sorry, can you simplify your question, Your Excellency?
Yes. So if I'm a state and if I'm asserting that I have the imminent state from, from this specific state, now I will have to establish the imminent threat from the acts of my opponent state, that they have, held such meetings that they are going to launch such missile on me, regardless, because there is no such, meeting has been held. There is no such, intention on part of the opponent state, on the part of the Roxana, that they are going to launch this specific missile on Azura. So how can you establish the notion of imminent threat?
Your Excellencies, United Provinces of Roxana is the leading country in the region with advanced military program production. And then, as we stated before, that the hypersonic nuclear missile can constitute as an imminent threat to our national security, whereas that possession could inference as a willingness to use them.
Council, this way, any state can claim that we are having such a threat from this state, and that's why we are launching this attack. Like, is it reasonable to you to say that because the imminent threat, whenever we argue before the court of law, we need to fulfill certain legality or certain legal requirements of the words. Like, imminent threat is not just a linguistic English term. In legal connotations, it has some requirements. You can proceed, counsel.
Thank you, Your Excellency. Move to our second argument that Republic of Azura doesn't need to pay reparation. Republic of Azura didn't conduct any international wrongful act, since the attack didn't fulfill of the element of international wrongful act stated in Article 2 of RCWA. Since the Republic of Azura didn't conduct an international wrongful act, Republic of Azura doesn't have to pay any reparation for the damage suffered by its attack on United Provinces of Roxana, as stated in Article 31 RCWA. Unless Your Excellencies have future questions, this concluded our argument. May it please the court.
Council, I would like to pose a last question that, in the facts, there is a word preemptive self-defense. So what is preemptive self-defense?
Preemptive self-defense is the doctrine of self-defense where there is an absence of armed attack, then you invoke your right to defend yourself, but there is an imminent threat to it, Your Excellency.
Okay.
Thank you. You may please look on.
Thank you.
So for the first applicant, would you like the judges to continue asking questions or move on to the next speaker?
Sorry? Can you please repeat, Chesty?
Would you like to move on to the next speaker for the first applicant? Yeah.
Yes. Yes,
For the
please.
second applicant, you may move on.
Okay.
Thank you. Good morning, Mr. President, Your Excellencies, may it please the court. My name is Johanna. I am the co-agent appearing on behalf of Republic of Azura. As introduced by the first agent, I will be dealing with the second submissions in the next 17 minutes. I have the honor to address applicants' final submissions concerning United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparation to the Republic of Azura for the damage suffered. If there are no preliminary inquiry, we would like to continue to our submission.
Council, your applicant speaker to a respondent applicant? Respondent speaker.
We are the applicant, Mr. President.
Okay, okay.
Your Excellencies, may it please the court. On 29 October 2022, Roxana launched their hypersonic nuclear missile against Octagon that located in the heart of Republic of Azura's capital city, a bustling metropolis with a population of 8 million people. The attack was caused Octagon struck with immense force, causing a massive explosions that instantly obliterated the military command and control center with hundreds of thousands casualties reported in the immediate aftermath. many of whom suffered from severe burns, radiation sickness, and other life-threatening injuries. In light of these matters, there are three questions that need to be entertained by this court. Firstly, the launch of nuclear missile is unlawful under international law. Secondly, targeting Octagon is a violation under IHL. And lastly, Azura did not have any obligation to pay for the compensation. Your Excellencies, moving to our first major argument, we submit that the launch of nuclear missile is unlawful under international law. It's because the attacks against the Republic of Azura was unnecessary. Self-defense is the exception for the use of force under the Charter. In Nicaragua, to classify the attack as a self-defense, it must be necessary and proportionate. Regarding the necessary, here we submit that the nuclear missile attack was not necessary. Necessity exists when the situation is instant, overwhelming, leaving no choice of means and no moment of deliberations. States are allowed to attack military as long as it is necessary to gain military advantage. In Nicaragua, the court refers to the target of the attack, which only targeted towards military objectives and did not threat the civilian population. Since the use of nuclear missile threat and causing an indiscriminate attack to the civilian, thus the use of nuclear missile was not necessary. Secondly, the nuclear missile attack was not proportionate. Proportionally of an attack requires the balance between the destructive effect and undesirable damage. Under IHL, states are prohibited to launch an attack if the damage anticipated to the civilian would be excessive compared to the military advantage pursued. In Gallic, the chamber established that an act is proportional.
Council,
Has
your
taken
voice is
into
breaking.
account the anticipated damage to the civilian from the information available relating to the target of the attack. Here, the Azura's attack caused access. Yes, Mr. President, can you please repeat your question?
Is it me or is it for everyone? Like, I can see the I can,
Yes,
not
since
clearly
I have
listen.
bad
Okay.
internet connection. Turning to our second sub-argument, we submit that
Sorry, Council, I'm unable to hear you.
Turning to our second sub-argument, we submit that targeting Octagon is a violation under international humanitarian law. Targeting Octagon is a violation under international humanitarian law because first, Octagon is not legitimate military objective. In targeting a specific target, a party must consider the target as military objectives. Article 52, paragraph 2 of the Additional Protocol 1 give a strict limitation to consider to consider a military objective, which are make an effective contribution in military action and offers a definite military advantage. Turning to our first threshold, here we submit that Octagon did not give an effective contribution. In NATO bombing, the presence of civilians is an essential element to consider a target as a military objective, even if the civilians are within or near a military object. The situation must be avoided due to military objective being determined by an object's location. Since the Octagon was located in the heart of Republic of Azura's capital city, with the presence of a million population of civilians, thus the Octagon did not give an effective contribution. Secondly, targeting the Octagon did not offer a definite military advantage. The additional Protocol 1 requires that the military advantage of an attack which cannot offer merely an indeterminate or potential advantage, it must offer a definite military advantage. And to determine the definite military advantage, it is necessary to consider the latest information before the attack is launched. In the present case, Roxana did not collect any information before attacking the Octagon. Therefore, the Octagon does not offer any military advantage. Moving to our second major argument, we submit that the attack violated the principles under IHL because first, the operation did not fulfill the principle of distinction. In the nuclear case, the court stated that targeting an object must be in accordance with the principle of distinction. To determine the attack has breached the element of distinction, it has fulfilled that first, the attack is directed against the civilian population and aware that the attack will result in the indiscriminate damage to the civilian. To prove that the operation did not fulfill the principle of distinction, here we submit that first, Roxana attack was directed to the civilian population. To prove that the attack directed to the civilian population, in Galip, the trial chamber required the prosecutor to authenticate that the perpetrator was aware that the target was also directed against the civilian. Similarly, Roxana also aware that the use of nuclear missile will cause an injury to the civilian. Thus, Roxana attack also directed against the civilian. Secondly, launch the nuclear weapons, resulting in indiscriminate damage. The trial chamber in Kupreski refers to the proportionality principle, stating that even if the military targets are legitimate but causing indiscriminate damage to the civilians, the attacks still are unlawful. In accordance with Article 57 of Additional Protocol 1, it is compulsory to spare the civilians object to minimizing incidental loss of civilians and avoid indiscriminate attack during the hostilities. Here, the impact of the launch of nuclear missile not only destroying Octagon, but also resulting in civilian casualties. Turning to our second sub-argument, we submit that the launch of nuclear missile has breached the principle of precaution. Yes, Mr. President?
Council, is Roxana State treaty has ratified the Treaty of Non-Proliferation of Nuclear Weapons? Are they signatory of the treaty?
Mr. President, both of these countries is not ratified the non-proliferation treaties.
Yes. So they have not ratified.
Yes, Mr. President.
And does IHL provides for, or is there any explicit provision about prohibition on the nuclear missile weapons?
Mr. President, there is no explicit about the prohibition of the nuclear weapons, Mr. President.
Right.
But
okay, so when there is no explicit provision about that, if the Roxana has not ratified the said treaty, is not signatory to it, so how can they, how can they abide by or comply with something they have not ratified, or there is not explicit provision about it? So how can they feel, obligated to comply with these essential elements.
Mr. President, even though there is no explicit prohibition of the use of nuclear weapon, but in additional Protocol 1 Geneva Convention, it is stipulated that this prohibit to use method or means that cause injury or injury to the civilians. Here, the use of nuclear missile was causing injury to the civilians. Thank you.
Council, one more question. As you know, I tried to grasp it from your co-counsel as well. That isn't it, a very irresponsible behavior on the part of Azura State as well. Like they were very much cognizant of the fact that they are having this advanced missile, and and then launching attack on them is does it tantamount to inviting a very hostile war between the two states. So wasn't it very irresponsible on part of like other remedies were available and that should be exhausted before some diplomatic obviously in the facts there are mention of the facts that there are certain cooperation was extended out to the Roxana state, but still international community could be resorted to more rigorous diplomatic or security council meetings should be conducted before resorting to such a hostile method. So don't you think that it was a very irresponsible behavior on part of Azura state as well?
I'm sorry, Your Excellencies. Can you please simplify your question?
Okay, so what I'm saying is that Azura state was very much cognizant, was very much aware of the missile that they are, preparing such advanced sort of missile, and despite of this fact, they launch attack on them. So wasn't it very irresponsible on part of Azura state as well? Because they are the one who initiated this war.
Mr. President, our attack is as our last resort and to protect our nationality, and it's to eliminate threat and protect our sovereignty, Mr. President.
So how is it last resort? What are the other, resorts that you had and you had exhausted that, but that failed? So what other options did you have and then you resorted to?
Mr. President, the launch of Azura's military attack against our country was over our country to was destroy our military command. That's why that was our last resort to protect our.
No, but they have not launched that missile against you. They have they did not had any intention to launch that missile against you. Nor the two states were in hostile relations with each other. Like facts are silent about this fact. So how can you say that?
Mr. President, we always open for the diplomacy with the United Provinces, Republic of Azura.
So are they like they have their foreign ministry office has also launched their statements that we are also open for diplomacy and for the talks. But that is not the justification. If the diplomatic talks have been failed, is it the justification to launch such a hostile, such a hostile attack against the opponent state, which you do not have any, imminent threat against you? Because I'm not convinced that there was any imminent threat. And that is despite the fact that they are knowing that they are such military advanced country and they have every sort of weapon at their disposal.
I'm sorry to interrupt, Your Excellency. The second speaker has run out of time.
Okay, okay. Please wrap up in just 30 seconds, please, Council.
Mr. President, here we conclude that Roxana violated international law by launching their military attacks against Azura, and Roxana have to pay reparation to the Republic of Azura for the damage suffered. Thank you. May it please the court.
For the respondent, you may proceed.
Good morning from Jakarta. Your Excellencies and juries, my name is Sairama Agung Takataran, and I appear on behalf of the respondent, United Provinces of Roxana. I will be addressing procedural arguments on the first submission and second submission. I'll be speaking on these matters for 15 minutes, and we respectfully reserve 5 minutes for rebuttal.
Council?
Yes?
Can you please repeat your name?
My name is Zahir Remal Agung Takataran.
Zahir Rahman.
Zahir, Your Excellency.
Right. So,
may it please the court. Your Excellencies, if there are no preliminary inquiries, I shall continue to briefly explain the dispute between both parties that has been brought up upon this Honorable Court of Justice. Member of the court, the dispute between the Republic of Azura as the applicant and the United Provinces of Roxana as the respondent arose since 1 September 2022. Tensions between the United Provinces of Roxana and the Republic of Azura escalated due to the development of a new hypersonic nuclear missile by the United Provinces of Roxana. The Republic of Azura pursued a multi-pronged approach to counter the perceived threat, increasing intelligence gathering efforts, engaging in a campaign to pressure the United Province of Roxana, and upgrading and modernizing their defense system. The United Provinces of Roxana have asserted their military advancements and necessary to protect their sovereignty, leading to tension between two nations. On 29 October 2022, the United Provinces of Roxana deployed a hypersonic nuclear missile to turn the tide of the war and force the Republic of Azura to reconsider its aggressive actions. The missile was launched with the specific target of the Octagon, Republic of Azura Military Command and Control Center. The Octagon was struck with an immense force, causing massive explosion throughout the city. The human toll was unimaginable. Therefore, on 2 November 2022, the United Nations Security Council convened an emergency session to address the escalating crisis between the Republic of Azura and the United Province of Roxana. Your Honor, from such circumstances, respondent would like to submit two procedural arguments, which are: applicant violated international law by launching military attacks against respondent and must pay reparations for the damage they suffered. And second, respondent acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and need not pay reparations to applicant for the damage suffered. If it pleases Your Excellencies, I will begin with the first argument. In the first argument, we submit that Azuras violated international law by launching military attacks against respondent and must pay reparations for the damage suffered. Members of the tribunal, in this present case, the Republic of Azura did not meet the requirement of self-defense and clearly violated the UN Charter. Without ever achieving real threats posed by respondent, applicant launched a preemptive strike, multi-pronged conventional attack against respondent, deliberately utilizing the land, air, and naval forces in a coordinated assault. The offensive was swift and devastating, resulting in widespread destruction throughout respondent. Applicants violated the UN Charter and did not meet the requirements of self-defense due to two reasons. Your Excellencies, first of all, there are no armed attacks against the applicant, and there were no real threat posed by the respondent. If I may direct Your Excellencies' attention to Article 51 of the United Charter, it clearly stated that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. This sentence clearly proposed meaning that there must be a clear visual and actions of an armed attack towards members of the United Nations, which is the applicant. But Your Excellencies, if we analyze from the case, the act of preemptive strike with the title of the self-defense by the applicant clearly violates the UN Charter because there were no armed attacks happening against applicant, nor real threats by the respondent. Thus, the act of preemptive strike by the applicant cannot be called as self-defense. Second of all, Your Excellencies, the applicant did not report the act of self-defense in the form of preemptive strikes to the Security Council. Your Excellencies, if we again refer from the Article 51 of the UN Charter, it is also stated that measures taken by members. Yes, you may, Your Excellency.
Council, you are refuting the fact that there was no imminent threat, but you are up to something which can destroy the peace and tranquility of the whole region. How can you say that there was no imminent threat? And considering the neighborhood and the regional connectivity of your state and the Azura state, so there was imminent threat.
May I answer your question? Your Excellencies. The applicant clearly launched a preemptive strike, which is as a form of self-defense towards a respondent. We called it imminent threat because it has already been clarified by Roxana itself, and it is the true purpose of making the nuclear weapon. And okay, I'm sorry, Your Excellencies. So respondent respond by using the nuclear weapons towards applicant, which causing destruction and disrupting the peace in the region. It is for maintaining the respondent's sovereignty, Your Excellencies, because if we refer from the case, the act of preemptive strike by the applicant is causing massive and widespread destruction throughout the respondent. And by the case, the respondent have no more actions left. There are no armed forces. All of the armed forces are destroyed. All of the civilian objects are destroyed because it is massive and causing a widespread destruction throughout the respondent. Therefore, in order to maintaining ourselves, to maintain the respondent, we need to turn the tide down by using the hypersonic nuclear missile. I hope that answers your question, Your Excellencies. May I continue with? Yes,
Council, the very sovereignty of a state is not dependent upon its security or the sort of weapons they accumulate in their land. So the sovereignty, the principle and notion of sovereignty is very much intact, even if a state has no security for that matter or has no military weapons as advanced as any other country. So there is no requirement of such thing. Plus, from you were saying the sovereignty, when the sovereignty is challenged, yes, when the sovereignty is challenged, then you can say that attack has already been launched, and then we want to have such a mass scale level of weapons because our history is of such a nature that already a lot of attacks have been launched against us, and now we are accumulated such sort of weapons that violates every possible principle of IHL. So your sovereignty has not been infringed. You had the sovereignty. But why to accumulate such a high advance, which can possibly and can potentially pose a great challenge to the tranquility and peace of the whole region?
May I answer, Your Excellencies? Uh, Respondent acted with the hypersonic nuclear missiles because, as we have been stated, we have been stated before, that the act of preemptive strike by the applicant is causing massive destruction and widespread catastrophe throughout the respondent. That widespread destruction destroyed all of the armed facilities, all of the armed forces in the respondent. It is clearly stated in the case that the applicant launched a preemptive strike, multi-pronged conventional attack against respondent, and resulting in widespread destruction throughout the respondent. There are no more armed facilities left. There are no more power in respondent. But yes, Your Excellency.
My question is not about self-defense and why you have launched a nuclear missile. My question is about the very accumulation of or very making of forming and making such an advanced nuclear missile, which can jeopardize the whole humanity. Because you are very much familiar, you may be very much familiar of the fact that it has nuclear radiation, which can which cannot distinguish even between military objectives and civilian objectives, and all are same in that. So I want a justification for this.
If I may answer your question, Your Excellencies, I would like to simplify that. What is the reason for us respondent to create nuclear missiles? Right. Our reasons is that our purpose of making the hypersonic nuclear missiles is to protect our sovereignty, and there are no regulations that revokes there are no regulations that doesn't say no to making nuclear weapons. It is our territorial integrity, our power of sovereignty to make nuclear weapons. Because if we refer from the case, respondent is a nation with advanced military technology. Thus, to further improve our sovereignty, so that to further improve our sovereignty, to further improve our nations, we need to improve our defense, such as improving our hypersonic nuclear missiles. And also must keep in mind that there are no regulations that did not obligate the making of hypersonic nuclear missiles. There are no regulations that prohibit the making of hypersonic nuclear missiles. Your Excellency.
Council, there are certain customary international humanitarian law principles. Even if you are not signatory to any particular treaty for that matter, you have to comply with those principles at any cost, because those are customary and their applicability is not contingent upon any ratification. So, the very essential element of the distinction between military and civilian objective, that is, being violated by, making such a weapon and then launching it against a state. Because whatever there were certain results before launching of such nuclear missile, because that, resulted in killing of hundreds of thousands of civilians. Like, it cannot distinguish between military and civilian population. Plus, it is quite, it doesn't cater to proportionality principle, because the very nuclear, missile doesn't know the proportionality, cannot entail the proportionality element in itself, because there is radiation which can, which can make lands even uninhabitable for many years to come. So what about these principles of IHL?
Right. May I answer your questions, Your Excellencies? our reasons for improving our military advancements by making the hypersonic nuclear missile is not to destroy other nations and disrupting the peace and balance in the region, but we make it only for our own self-defense, only for our improvement, military improvement. Because, Your Excellencies, if we improve our hypersonic nuclear missiles, it will improve other aspects in our military advancements, such as if we improve our nuclear reactor, it will help with many things inside of respondent, such as electricity, such as many resources that will potentially make the full use of our nations, Your Excellency.
Council, this argument would have much weight if you had not launched the nuclear missile against Azura.
Yes, we launched the hypersonic nuclear missile, Your Excellencies, because the Republic of Azura, the applicant itself, violated the international law, and without threat posed by us, posed by respondent, the applicant causing massive and widespread destruction throughout the respondent. Therefore, we do not have anything to do except our last resort, which is hypersonic nuclear missile, to turn the tide upside down, to protect our own sovereignty, our own territorial integrity, Your Excellencies. We need to protect our own nations, our own sovereign nations, as we are also part of the United Nations, Your Excellencies.
So it means you are admitting some way that launching such attack amounts to violation of international law, because the international law clearly prohibits such usage of weapons.
No, Your Excellencies, but Republic of the applicant itself destroyed our own sovereignty.
The time has lapsed. Please answer in 30 seconds and then wrap up.
Your Excellencies, we use our hypersonic nuclear missile is just for the survival of our nations, Your Excellencies. We do not. We use it just for our own national survival, when applicant did not even give us any chance to make diplomatic talks. It is our last resort, Your Excellency.
Okay, thank you.
Mrs. Moderator, do you still have time?
The first respondent has run out of time, so we should proceed to the second respondent.
Thank you very much. I have reached the end of my pleadings. If there are no more further questions, I conclude my submission. Thank you.
Good morning, Your Excellencies. My name is Raihan Case Tufelubis, and I will be speaking with the second argument. We submit that Azuras violated international law by launching military attacks against respondent and must pay reparations for the damages suffered. Your Excellencies, in the present case, the Republic of Azura did not even meet the requirements of self-defense and clearly violated the UN Charter, especially Article 51, the states that self-defense must be commensurate with the must be commensurate if the attack already occurs to the injured state. Your Excellencies, as I have said before, applicants violated the UN Charter and did not meet the requirements of self-defense due to pardon me, Your Excellencies. Actually, Your Excellencies, you can follow me to Article 2, Paragraph 4 and the Article 51 of the UN Charter, which doesn't revoke individual rights of self-defense if an attack occurs against a member of the United Nations, with the respondent being a member of the UN. On top of that, the preemptive strike committed by applicant against respondent compromised respondent's territorial integrity, which resulted in the illegal occupation of respondents' critical infrastructure, such as power plants and transportation networks. Also, Your Excellencies, applicants' coordinated attacks on precisely guided airstrikes turned respondents' air defenses, radar installations, and other military installations into piles of rubble, which rendered respondent defenseless from applicants' aerial and naval attack, as my co-counsel have stated before. Because of that, respondent had no choice but to deploy its hypersonic nuclear missile at Octagon only. Applicants comment, the Octagon is an applicant's command and control center. Now the use of WMDs, or weapons of mass destruction, such as hypersonic nuclear missile, is legal since applicants illegally occupied respondents' military installations and civilian objects, which brings us to Article 51 of RCWA regarding proportionality, which in this context of employing a nuclear missile of self-defense must be assessed in terms of need and degree of damage in comparison to the threat being resisted. The concept of proportionality requires that the response or action taken be proportional to the threat faced. In this case, the respondent was subjected to an initial attack by the applicant, targeting critical infrastructures and military installations, which resulted in significant economic damages and seizure of power plants and transportation networks. Now, the applicant may argue that the targeting of power plants and transportation networks is legal, but according to Article 52 of Additional Protocol 1, attacks shall be limited strictly to military objectives. Insofar as objects are concerned, military objects are limited to those objects which by their nature, location, purpose, or use make an effective contribution to military action and whose total of partial destruction, capture, or neutralization in the circumstances ruling at the time, which in this case, now power plants, you may think that power plants can be used to develop nuclear weapons, but not. Nuclear power plants are usually used for, electricity and stuff. Now, continuing to the use of WMDs as self-defense in the context of the self-defense is referred to the Nicaragua case versus United States of America of 1986, where the International Court of Justice determined that Article 51 is a part of customary international law, and that the use of force in self-defense against an armed attack is only permitted without prior Security Council approval if the attack is substantial. Then on that basis, the respondent may use nuclear weapons for the purpose of self-protection. Correlating with my previous plea regarding proportionality of the damages suffered and the damages caused by the missile, respondent does not need to pay reparations. Your Excellencies, I have reached the end of my pleadings. If there are no further questions, that conclude my submissions. Thank you. And may it please
Counsel?
Yes, Your Excellency.
Do you rely on any case law or any jury's opinion for that matter, which says that, when such attack has been launched by your opponent state and at last resort, you can, launch something which can pretty much violates every possible principle of IHL? Counsel, you're muted, I guess.
All right, Your Excellencies, I will refer to the legality of the threat or use of nuclear force by a letter dated 19 December 1994, filed in the registry on 6 January 1995. The Secretary General of the United Nations officially communicated to the registry a decision taken by the General Assembly by its resolution 49/75K, adopted on 15 December 1994. The following question: is the threat or use of nuclear weapons in any circumstance permitted under international law? The resolution asked the court to render its advisory opinion urgently. Written statements were filed by 28 states, and I will proceed with the answer of the court. The court then considered the question of the legality or illegality of the use of nuclear weapons in light of the provisions of the Charter relating to the threat or use of force. It observed inter alia that those provisions apply to any use of force, regardless of the weapons employed. In addition, it stated that the principle of proportionality might not in itself exclude the use of nuclear weapons in self-defense in all circumstances. However, at the same time, a use of force that was proportionate under the law of self-defense had, in order to be lawful, to meet the requirements of the law applicable in armed conflict, including in particular the principles and rules of humanitarian law. It pointed that the notions of a threat and use of force within the meaning of Article 2, Paragraph 4 of the Charter stood together in the sense that if the use of force itself in a given case was illegal for whatever reasons, the threat to use such force would likewise be illegal.
Council, what is the resolution number?
49/75K.
All right. Thank you.
Your Excellencies, may I continue with my regarding
Yes, sure.
the legality of the what? Excuse me, Your Excellency.
Yes, you can proceed if
Okay,
you have
thank
time.
you. I will proceed. I will proceed within the legality of the threat or use of force by jurisprudence or opinions of the judges. The court then turned to the law applicable in situations of armed conflict. From a consideration of customary and conventional law, it concluded that the use of nuclear weapons could not be seen as specifically prohibited on the basis of that law, nor did it find any specific prohibition of the use of nuclear weapons in the treaties that expressly prohibited the use of certain weapons of mass destruction. The court then turned to an examination of customary international law to determine whether a prohibition of the threat or use of nuclear weapons as such flowed from that source of law, noting that the members of the international community were profoundly divided on the matter of whether non-recourse to nuclear weapons over the past 50 years constituted the expression of an opinio juris. It did not consider itself able to find that there was such an opinio juris on this matter. The emergence as lex lata of customary rules specifically prohibiting the use of nuclear weapons as such was hampered by the continuing tensions between the nation opinio juris on the one hand and the still strong adherence to the doctrine of deterrence on the other. The court then dealt with the question whether the recourse to nuclear weapons ought to be considered as illegal in the light of principles and the rules of international humanitarian law applicable in armed conflict and of the law of neutrality. It laid emphasis on two cardinal principles. A. Your Excellencies, that conclude my answer to your question regarding opinion juris of this legality of the nuclear use. May it please the court.
Thank you, Council.
I'm sorry to interrupt. Your Excellency, would you like to continue asking the second respondent since he still has around 4 minutes left?
I do not have any question because I have asked them. If my if the council has any questions, she may proceed.
So for second respondent, do you still have anything to add? You still have around 4 minutes left.
I think we should proceed.
Actually, respondent, I am already done with my procedural argument. We may proceed.
Okay. Okay, so we should proceed to the rebuttal session.
Your Excellencies, representing the applicant state for the rebuttal session, here we address that, as mentioned before from the respondent state, that the nuclear weapon is not a threat. Here we stated that the nuclear weapon is a threat, since they stated that it's to assert their sovereignty. We see there is no point to assert their sovereignty, not necessarily to develop nuclear weapon to assert their sovereignty, since they're the leading country for military advanced technology. Second, we submit that the public of Roxana is unaware of the danger of nuclear weapon, and there is no transparency on the development for this hypersonic nuclear missile. It is also stated in the paragraph 9 and 38 of the facts that Republic of Roxana is not aware of the environmental risks and the health effect that the nuclear weapon possess. Secondly, thirdly, we submit that the respondent state said that it is not a legitimate military object when we attack their communication hub. But if I may refer to you, Your Excellency, in the final report of the NATO bombing case, the ICRC drew up the following threshold for military objects. And if I may, if I may explain to you, though in paragraph 39, number 6, those of the lines and means of communications such as railway, roads, bridges, tunnels, and canals. Furthermore, it is also stated in paragraph 8 of that same report that factories or plane constituting other production and manufacturing centers of fundamental importance for the conduct of war, such as metallurgical, engineering, and chemical industry, whose nature or purpose is essentially to military. Therefore, our attack is directly led to a legitimate military object. And lastly, if I may refer to you, the United Security Council launched their resolution number 2087, where United Nations Security Council condemned the development of nuclear weapon by North Korea. This can constitute as the state practice where, even though there is no international legal framework that explicitly stated that it is prohibited to develop a nuclear weapon, but the United Nations Security Council has launched their resolution regarding the development of nuclear weapon by North Korea. Your Excellency. Thank you. That should conclude our rebuttal session. May it please the court.
For respondent team, you may proceed for the rebuttal session. Thank you.
Thank you very much, Your Excellencies, for the time. I will be addressing our rebuttal for 5 minutes. As earlier on the pleadings, applicant said that there are armed attack occurs first as a form of self-defense. Your Excellencies, if we refer from the case, there are no armed attacks occurs against respondent, and the applicant did not immediately report it to United Security Council. Thus, it cannot be called as a form of self-defense. Second of all, the applicant on the pleading said that applicant's attack of preemptive strike only attack military installations, and it is proportionate. Your Excellencies, applicant attack respondent, causing widespread destruction throughout respondent, resulting injury to not just civilian objects but also civilian. Your Excellencies, it is widespread destruction throughout respondent. Of course, it will risking the life of civilian objects. And third of all, the applicant from the pleading said the applicant has exhausted all ways and called imminent threat of called the hypersonic nuclear missile an imminent threat towards respondent. And resorted to armed attacks or use of force to respond. Your Excellencies, there are, as we have said on the previous, that the hypersonic nuclear missiles exist only to protect our own sovereignty, only to further improve our own nations. Therefore, there is no imminent threat. There is no imminent threat posed by respondent. Thus, the act of preemptive strike by the applicant clearly is a use of force that violates the international law. Next to my rebuttal, applicants in the pleading said that Octagon did not effective. The attack against Octagon did not give effectiveness towards respondents towards respondent. Your Excellencies, as referred from the case, applicants' armed force, military command, and control centers are in Octagon. All of it are most essential to turn the tide of war. The applicant violates the principle of distinction, whereas applicant put together all of the important, such as armed force, military command, and command control inside the heart of a city, a heart of nations. It clearly is a violation of principle of distinctions in international humanitarian law.
And now for the rebuttal. Applicant in rebuttal session stated that power plants and transportation networks are considered as military objects. Well,
Counsel?
Yes, Your Excellency.
Isn't rebuttal is supposed to be covered by only one speaker?
Right. Thank you very much for the notifications, Your Excellencies. From the rebuttal sessions, Article 51 stated that the proportionality, as long as it's Your Excellencies, the applicant destroyed the transportation networks and which is considered as military objects. Therefore, it is a violations regarding the international law. The act of preemptive strikes also did not fulfill the criteria for launching a self-defense, Your Excellencies. According to the customary law, if it refers from the Caroline case of the the United States Secretary General Daniel Webster described a criterion to be called as a self-defense. It is instant, overwhelming, leaving no choice of means and no moments for deliberations, Your Excellencies. The act of preemptive strike by the applicant clearly did not fulfill the criteria of leaving no choice of means and no moment for deliberations. Those 2 points essentially stated that there are no more ways to pay except resorting to defend oneself. But for the case of applicant, there are still many ways to explore, Your Excellencies. There are still many ways to explore diplomatic avenues. The applicant did not explore everything on diplomatic avenues, but diplomatic on the argument of self-defense just provoke a use of force towards a nation that have never proposed a threat towards the applicant. Next, Your Excellencies, the act of preemptive strike by the applicant undoubtedly violates the international humanitarian law, which is the fourth fundamental principle of international humanitarian law, which violates the limiting unnecessary suffering and proportionality. First, limiting unnecessary suffering. If we refer from Article 35 of Additional Protocol 1, it is prohibited to employ weapons, projectiles, and materials and methods of warfare to cause superfluous injury or unnecessary suffering. If we analyze from the case, the act of preemptive strike by the applicant took out the respondent, destroying power plants, transportation networks, and communication hubs, and many other civil objects.
Counsel?
Yes, Your Excellency.
How much time you had reserved for the rebuttals?
5 minutes, Your Excellencies.
Yeah, so I guess there is too much time that you have taken.
Okay, Your Excellency. We are very sorry. You may, Ms. Moderator.
So, Your Excellency, do you have anything to add?
As a feedback?
Sorry?
What I'm supposed to do? Giving a feedback?
So I think if we have ended the rebuttal session, so that concludes the round. So We will adjourn the participants to the deliberation room for further proceedings. So, Your Excellencies, please note that we have up to 15 to 20 minutes for you to complete your score sheets. Kindly score your participants' performance based on the provided criteria. Once completed, please email the score sheets back to the organizer at competition@ILSA UniSZA.my. Please take your time to deliberate and complete your score sheets.
Can we leave now?
Your Excellencies, may I have a moment? I will assign the participants to a breakout room. Participants, please enter the breakout rooms. Great. Judges, you may begin your deliberation.
All right. I guess one of the participants is still here. Okay, so Khan sir? This was room 1, right? This is room 1.
Yeah, this is room 1.
And round 1.
Round 1. Yeah. Preliminary round 1.
Please tell me what was the name of the second speaker. Do you know the names of the speakers?
Khan sir, your voice is too low.
Sorry to interrupt. Ms. Katsa, I'm unable to hear you. Would you speak louder?
Am I audible now?
Yes, you are.
Okay, so I was just asking the name of the second participant from participants.
Trace, can you provide them with the names of the applicants? Your mic is muted.
Is it okay if I write in the comment section? Or
Unfortunately.
I just read out the names?
Read out the names, please.
Can you please
Plus
clarify how much mark is each for the like knowledge of law, guessing,
20 points per category.
20 points for each category, right?
Yes. May I clarify? You wanted to know the names of the applicants, right?
I have like the first applicant name was Afik Ahmed, and second applicant name was I guess Johanna, and then first respondent name was Zahir Rahman, and second was Rehem.
Mm-hmm.
I might be mistaken.
It is correct. Ms. Kansa, do you require any assistance regarding the names?
I just wanted to confirm.
All right. If you require any assistance, please do let me know. Chase, may I confirm? Has the feedback session begun?
Not yet.
All right, so I will just remove the participants who are present in this room right now.
I think there are no participants here. They are just requesting to join.
I see. All right.
Hmm.
Okay, I'm done with the score sheet and I have sent it on email.
Okay. Let me check on
Shall
my
I send
email.
you on WhatsApp as well? Just
Sorry?
shall I send you on WhatsApp as well the score sheet?
It's okay. Let me check on my email first. Have I received the email? Done. Yeah, I've received the email.
Okay.
Thank you, sir.
Thank you.
Formula could be upside access of it. Have you noticed any diarrhea since the change? Yeah, we have.
Ms. Kansa, sorry to interrupt. Is everything okay? Or else you can email to us later, because now we are going to start the feedback session. Ms. Kansa, can you hear me?
Unfortunately, you are breaking out. We can't hear you very well.
I just sent you the score sheets. Am I audible now?
Yes, you are audible. However, it doesn't seem like the score sheet has reached us yet. But that is all right, Ms. Kansa. We will reach out to you regarding the score sheets after this again. So shall we proceed to the feedback session? Great. So I will add the participants back to the main room. Participants, may I request that you mute your microphone? Okay, apologies for making you wait. Or Chase.
Okay, so shall we start? Okay, so
Please do.
Right, so I'm going to give a very generalized sort of feedback for all four of you. The round was very impressive. Your arguments, your oral presentation, your demeanor, your overall etiquettes of the court was quite impressive. Starting from Afiq, you were quite good, but I guess you need to work more on your advocacy and how to handle questions and not just to be losing nerves to. And this is for everybody. I'm giving this very generalized feedback. Don't lose nerves whenever judges ask a question, and just you can take 5 to 10 seconds and just think about what answer you want to give to them, and that should be obviously in light of law. Secondly, the problem, not a problem, but I guess you guys are quite young for the moods. But despite of this fact, you guys did a remarkable job. Um, One thing I faced is that your arguments were not that much in light of law and in case law. Whatever you are saying, whatever you are asserting, you should always substantiate it with the relevant provision of law. Even before citing a case, Afik, you should cite a case law, sorry, a law first. That this is the provision, like the Article 51 of the UN Charter deals with self-defense, and these are the requirements, and the requirements have been laid down in this specific case, and these requirements are now fulfilled by the facts at hand. Now, your argument should focus on fulfilling the requirements of the law, and not don't make generalized sort of arguments. Do it in light of law. That is what law says. and that is what the requirements had been laid down by case laws, and this is the overall jurisprudence, and these are the facts which fulfills all of these essential elements of the law, and that's why we are invoking it. That way, your argument will be legal, and that's how lawyers should do argue, because everybody do arguments, but what stand out lawyers from all the other debaters is that they argue in light of law. Second of all the all your assertions, there are plenty and plethora of case laws out there. If you would have, research a bit more, you would have, get your hands on plethora of case laws. So, also from to the respondent team, one of the speakers, I may not recall his name correctly, but I guess his name is Zahir Rahman, right?
Yes, Your Excellency.
Yes. So, Zahir, what mistake you were repeating during your oral pleadings was that there were too much of hand gesture. You were, your overall behavior was not that serious. Like you were, um you were smiling. You were, whatever point you were making, you had this, wittiful face. So that's not how it works in courts of law. You should be more serious. There should be less of hand gestures. Um, and there are certain like etiquettes of moot courts which always you should comply with. Like it's not just a movie that you can, judges would be impressed by your gestures. No, your arguments should be and your overall voice and the inflections you give to your words should be quite uniform and standardized, and there should not be very, a lot of inflections in your voice. So that's how lawyers do arguments. Overall, it was a very good experience and good luck.
Thank you very much, Your Excellency.
My pleasure.
Yeah, I hope I'm audible.
Ms. Kansa, do you have anything to add
Am I audible?
regarding the feedback?
Am I audible?
Yes.
Alright, thank you. Well, I couldn't ask any question. Ebrar did a great job. So I would just like to say something which I observed during the whole proceedings. First and foremostly, I would like to emphasize that participating in a moot court competition is a valuable learning experience, and I hope at the end of the day you all have learned something. Uh, However, while reviewing your performance, I noticed a few areas that could be improved, and because obviously there is always a room for improvement. So, firstly, I would say that one should thoroughly understand the questions imposed and answer accordingly. Like you can take the time to analyze the question, identify the key issues, or craft your responses directly to address them. So one should understand what is the question imposed on them and then answer the directly, right? Secondly, I was observing that there was too much people reading from the respondent sides. So I would say that Am I audible? So I was just saying that it's important to refer to relevant materials or the papers, but it's equally crucial to maintain a balance between referring to your notes and engaging with the judges or your other participants as well. So yeah, this is all from me. Good luck.
Thank you, Miss Kansa, for your feedback. So I think that's the end of our preliminary round one. So judges and participants may leave this meeting. Thank you so much.
Thank you.
Thanks all.
Committee, can we leave the Zoom or leave the?
Yeah, you may leave this meeting. Thank
Okay.
you.
Thank you very much.
Okay, do we stop recording?
Yeah.
Okay.
Yay.
Right, we're done.
Yeah, I didn't expect it went quite smooth.
I was freaking out here. Because I had to restart the whole computer. Like maybe it's something with the computer.
Ah.
Wait. Oh, let me stop recording. Where's the recording?